Social Rules in South Korea. Part 1. When you have an excuse to do so. There are some occasions where you may not have to have legal liability for the loss or damage others suffered as a result of your conduct, even if you're negligent in doing that conduct. In South Korean law, there are what's called social rules that create exceptions to what otherwise would be considered a crime or civil wrong. If one of those exceptions applies to a certain behavior, someone who does that behavior has no legal liability. The problem lies in the fact that the word social rules has a very vague meaning. Its role in the continental law system adopted in South Korea is elusive. So what is the social rules supposed to mean? The way to get more or less acquainted with what it means is through the understanding of the sense in which the Korean courts use the term. There is a case of a foreign company that claimed to the Korean court that a certain behavior fell under an exception created by the social rules. It was a non-Korean company based overseas, outside South Korea, which had patented its invention in South Korea. One day in April 2008, the foreign company found a Korean company importing from overseas a certain product featuring something very similar to the invention it patented. The Korean company was supplying the imported products to a Korean retailer operating 140 supercenters throughout the country. The foreign company consulted a lawyer who advised that immediate action be taken to restrain the retailer from selling the imported products infringing on its patent. Among the lawyers that the staff at the foreign company had met in their business dealings, he was the guy they all thought could handle that the best. The foreign company engaged him as its lawyer and had him represented in matters surrounding the infringement of patent. On June 18, 2008, he wrote to the retailer saying the imported products were infringing on a foreign company's patent and that hopefully by June 30, 2008, it would cease to sell those products and that the foreign company intended to wait until then before considering any legal action. Sure enough, shortly after the retailer received the letter, it withdrew from the contract with the Korean company and the imported products in question became invisible in the Korean market. When the Korean company became aware of that, it was shocked it had happened. And it just so happened that, in November 2008, in a patent infringement trial against the foreign company, the Patent Court of Korea ruled that the product in question didn't infringe on the foreign company's patent. The Korean company thought it had missed out on the contract with the retailer and that something had to be done to take back what had been taken from it. You can also look at part 2 of this series to see what action was taken.